Hello and welcome to Verdictum. I'm Sheetal June, and in today's episode, we will talk about the Supreme Court's recent verdict interpreting the property law in India and limiting the government's power to acquire all kind of private property. The 9-judge Constitution Bench of the Supreme Court with 8-1 majority has ruled that not all privately owned properties can be classified as material resources of the community under Article 39B of the Constitution. Article 39B, which is a part of the directive principles of state policy, outlines that resources should be distributed to serve the common good. However, the interpretation in the ruling curtails the government's power to acquire and redistribute private property for the common good. The court, in its majority opinion, has clarified that only certain types of private property, based on their nature, significance, and impact on public welfare, could be potentially fall under this provision. The majority opinion, authored by Chief Justice of India D.Y. Chandrachud, with Justice V.V. Nagaratna partially concurring, marks a departure from more expansive interpretations rooted in socialist ideals as ceded by Justice Krishna Iyer in past cases such as the state of Karnataka versus Sri Ranganathan Reddy in 1977, wherein he had argued that privately held resources could indeed qualify as community resources if their acquisition served the greater good of society. This minority opinion of his influenced later rulings. However, all this now changes with the Supreme Court overturning the same with its new interpretation. Also central to this case is Article 31C, which was introduced in 1971 through the Constitution 25th Amendment to shield certain laws from being challenged on the ground of violating fundamental rights. Article 31C originally protected laws enacted to ensure that wealth and resources were used in ways that benefited society as their whole and prevented their concentration in private hands. The provision faced challenges over the years, including in the landmark Keshwananda Bharti case, which introduced the doctrine of basic structure, barring the Parliament from altering fundamental aspects of the Constitution, even through amendments. Since then, judicial interpretations have questioned whether Article 31C still exists in a modified form or not at all. This recent judgment reaffirms that Article 31C remains, but only as it was shaped by the Keshwananda Bharti decision, which limits its scope to Articles 39B and C. The landmark case began with the Property Owners Association of Mumbai challenging Chapter 8A of the Maharashtra Housing and Area Development Act of 1976, which allows the state to acquire privately owned buildings of cessed properties for restoration. The legislation amended in 1986 provided a framework for transferring private property to cooperative societies, asserting that this policy aligned with Article 39B of the Constitution by serving the broader public welfare. The POA and other stakeholders argued that such acquisition violated property rights and contended that Article 39B does not encompass privately owned resources. Originally filed in 1992, the case was referred to larger benches multiple times over the years and finally reached a 9-judge bench of the Supreme Court this year, which was tasked with determining the constitutional scope of Article 39B in relation to private property. CJI D.Y. Chandrachud's majority opinion, also agreed to by Justice Harishikesh Roy, Justice J.B. Pardewala, Justice Manoj Mishra, Justice Rajesh Bindal, Justice S.C. Sharma and Justice A.G. Masih, acknowledged that in theory, privately owned resources could qualify as material resources of the community. However, the judgment rejected the idea that all private properties could be automatically considered community resources simply because they have material value. The court emphasized that resources falling under Article 39B must demonstrate specific criteria such as scarcity, public welfare, impact, and consequences if concentrated among private entities. The ruling draws clear boundaries by explaining that the application of Article 39B is not at all encompassing rights of the government to seize or redistribute privately owned resources. Chief Justice D.Y. Chandrachud asserted that the nature and context of a property must be considered when assessing its community value. This approach deviates from a rigid ideological stance on state control over the private property rooted in socialism and rather offers a pragmatic case-by-case method centered in India's mixed economy. Justice V.V. Nagaratna, in her concurring opinion, underscored that while some private resources might serve the public good, items of personal use and small-scale assets should generally be excluded from the state acquisition. In his minority opinion, Justice Sudhanshu Dhulia dissented, warning the ruling's limitation on what can be considered communal resources might restrict the state's ability to bridge economic inequalities. In his view, maintaining the scope of community resources aligns with the spirit of the Constitution's directive principles. The verdict with this narrow interpretation can be said to be striking a balance between individuals' ownership rights and the government's social welfare objective. Thank you for watching the video. Hope it was helpful. For more such informative content, subscribe to our channel and download the Verdictum app on iOS and Android devices.